Today's webinar will be recorded. The names of the participants may be included in the records of this webinar. If you object to this, you can disconnect at this time. I ask that you please put any questions that you have during today's webinar in the Q&A. We will try to address as many questions as we can during the course of the webinar or after the webinar. You can also upvote any questions that are asked that you would like to have answered. It will compile them and raise them to the top of the list. So we'll get started today with today's webinar. The topic for today's webinar is the repatriation of cultural items under NAGPRA. Let me share my screen. For those of you who joined us last month, we discussed the inventory of human remains and associated funerary objects under the Act and the repatriation of those under the regulations. While I intended to cover the summary of cultural items and the repatriation of those cultural items last month, I was not able to fit it into the time allowed. So we're picking that back up this month. Just a moment while I arrange all my many screens here. Okay, so what you're seeing here on this slide are the table of contents that provide from the Act itself that outline the process for repatriation of human remains in an inventory and other cultural items through a summary. So our focus today is going to be on section 3004 of the Act and the related regulatory process. So under the Act, the summary provisions in section 3004 discuss what a summary is, what is required in a summary, when a summary is not required, and what is, when a summary is required and what is not required to be in a summary, as well as options for a summary, and then what happens after a summary is produced. Like last month, my plan for today is to walk through the various sections of the Act first, and then to go through the related provisions in the regulations. I see that we have somebody who cannot see my screen. Hopefully that is one person's problem and not a broader problem. I will, hopefully Lisa can assist the individual who cannot see the screen. Okay, so turning first to, again, in the Act itself, what is a summary? A summary is described in the law as being in lieu of, meaning in place of, an object by object inventory. So the definition of what a summary is it is not an inventory. A summary is based on available information held by the museum or federal agency. The requirements for a summary from the Act are to describe the scope of the collection, the kinds of objects included, geographical location and acquisition history, as well as cultural affiliation where ascertainable. So again, where available, that is the information required in a summary. A summary was due 3 years after the passage of the Act, or November 16th, 1993. Consultation is not required for a summary. This is one of the first and most significant changes or differences between the inventory process and the summary process. And that is that for a summary, consultation follows the completion of a summary. There is discretion in the summary provisions of the Act for Indian tribes and NHOs to request additional information about objects in a collection, and that information must be provided to them upon that request. After a summary is compiled, museums have continuing obligations to share information with tribes and NHOs as requested. They also have an obligation to return those cultural items once there is a request for repatriation, with 2 exceptions, and to consult on the transfer of those objects after repatriation. The 2 exceptions to repatriation are a delay for scientific study, or if there are competing requests for repatriation, and a most appropriate requester cannot be determined. So again, what I'm outlining here are the provisions that are in the Act. After a summary is completed or compiled, an Indian tribe may request repatriation if there is a cultural affiliation to the cultural items, meaning unassociated funerary objects, sacred objects, or objects of cultural patrimony. And that request must include this last statement here, which is again directly from the Act, and which is generally referred to as an assertion that there is no right of possession to the object. We'll talk more about that in the regulations. Indian tribes and NHOs may request repatriation of cultural items if they can show cultural affiliation, or they can show that the objects meet the definition of sacred objects or objects of cultural patrimony. So turning from the statute and the Act itself to the regulations. I see we have a request for copies of the slides. We are working to make these available on our events page where you registered for the session, along with the recordings of these sessions, so you can look for it there. So the Act gives us some parameters, but as hopefully you could see from that very brief discussion, there's still a lot of unanswered questions about the process for repatriation of cultural items. And that is what the regulations seek to do, is add more clarity and more information to the provisions that are provided in the Act. So we're going to turn here to subpart C of the Act, which covers repatriation of human remains and cultural items. And in particular, we're looking at section 10.9, which is the repatriation of unassociated funerary objects, sacred objects, and objects of cultural patrimony. Rather than saying those words and terms during today's presentation, I will likely say cultural items or other cultural items, and that should be understood to mean each of these specific categories. So much like last month, what I have prepared here is a summary of the step-by-step process under the regulations for repatriation of cultural items. In the first column under the check mark are the required parts of the step. Under the X in the middle are the things that are not required. That doesn't mean they can't be done. It just means that they're not required by the regulations. And then the question mark in the final column relates to those things that there's some discretion for the museum or federal agency to decide how to complete. So Again, for the first step, and really the first requirement for museums and federal agencies under the Act related to other cultural items is to compile a summary. And just like in the Act itself, there is a general description here of what is required in a summary. And that is the estimated number and general description of those cultural items, a geographic location, and by geographic location, it means where the artifacts came from. The acquisition history would include any history about how they came to be where they are today. If that is the geographic information that is available, that would be separate from where they were removed from or where they came from. In addition, a summary should include other information that is available about the objects generally, and then any information the museum or federal agency might have about how those objects were treated with potentially hazardous substances. Now, what is not required for a summary, again, it's not necessarily prohibited, but it's definitely not required to be done to compile a summary, is any kind of determination. There's no determination that must be made in compiling a summary. Physical inspection isn't necessary. Again, a summary can be compiled based on the information available to a museum, catalog cards, accession information, other descriptions of a collection. And you can see here additional items that are not necessarily required by the requirement of compiling a summary. How a summary is organized and the level of detail that it includes, and even the format of a summary, is up to a museum or federal agency. It is not dictated by the regulations. We have been working on a template for a summary. There has been a template available for a summary since 1991 or two in some format. We are working on revising what we previously were providing, but it's very similar. So if you have a previous template for a summary, it's still a good document to use, and we hope that either later today or early next week we'll be posting a template. I'll pause here actually to share the guidance that we did produce yesterday. Well, we've been working on it for a while, but we posted it yesterday. As hopefully you know, if you've been participating in these webinars, we are adding information to our policy page. You can find that at nps.gov/NAGPRA and navigate to law and policy. And this is where we're adding guidance documents as we are able to finalize them and publish them. And we added several new documents this month, including a guidance document on compiling a summary. This is that guidance document. Hopefully you can see that. And it starts with information from the regulations themselves, along with links. So you can read the information here or click the link and go to the online version of the regulations. And again, provides what is required for a summary. It also includes the deadlines for compiling a summary. And we have included here a handy reference to the definitions that relate to a summary. And I know that there were some questions in the chat about what the definitions are, or what some examples are of these different categories. And so those definitions are provided here. Again, the link takes you to the online version of the regulations themselves, but this is just a direct copy of that. And while we are still working on finalizing the template for a summary, we do have in this guidance document some examples of what summaries might look like. The first example here, a descriptive style, is one that is commonly used in a letter format, which basically describes broadly the collection a museum has. Alternates to a descriptive style are a table or a spreadsheet that describes them, or some kind of individual entry. Again, it's important to remember that a summary's purpose is to be broad and to be general. So while you could itemize an entry and make a more specific, exact document, it is certainly not required, but we've provided those as examples here. And then the final part of our guidance document is to provide some answers to some frequently asked questions related to this step in the process. So we have provided those here. And I know that many of you have a lot of questions, and hopefully before you ask them here in this webinar, you might be able to find the answer in this document. And I believe that someone has shared the link to that page. So I appreciate that. One issue that I wanted to address directly that I think that many of you may be wondering about is the question that's here in number 6. When should a summary be updated, and how does a summary that was previously submitted get updated? It's important to note that updates to summaries are not required. So a summary should be comprehensive, and it should cover any holding or collection that may contain a NAGPRA cultural item. Because a summary is a general description, it doesn't require updates, provided that that initial summary adequately described the entire collection. If, however, a museum or federal agency missed a part of its collection in compiling its original summary, then it might need to provide an additional summary of that additional collection and should follow the step 1 as if it were a new or previously unlocated collection. This is not really a change. Again, since the act was passed, a summary has intended to be a very general, broad description of a collection. But over time, many museums and federal agencies have decided to update a summary or to resend a summary. And while those are not prohibited practices, they are not required practices. So I just wanted to reiterate that if you work for a museum or federal agency that completed the summary process in 1993 and feel that that summary covers your entire collection, then there's no obligation to resubmit a summary. As I mentioned, we are still working on the template for a summary, but once that is ready, it will be here on the template page. Again, we've added some new templates. To this website in the last month, and you should be able to find those templates here. And again, we hope to be able to have a template for the summary soon. In addition, I wanted to point out another very helpful resource on our policy page, and that is the Steps to Repatriation document. This has been available since December. I think we didn't post it till January when the regulations were final, but it is a document that we finalized in December. And it provides a very detailed overview of what is required, but in a short format. Again, this is all information that's kind of abstracted from the regulatory language itself. On this page of the document, it gives you just a snapshot of each of the steps for repatriation of cultural items. So we've talked through step 1, but you can see here on this page all the way through step 7. There is, in addition, a another version of the same information that's in a colorful block format, and then a timeline for repatriation, which we'll talk through as well during this webinar session. So I just wanted to, again, make everybody aware of those resources that are available, and hopefully it will answer some of the questions that you have. So in looking ahead, the second step in the summary process, or the repatriation of cultural items process, is to initiate consultation. And again, this is the obligation for a museum and a federal agency, once they compile a summary, to send that summary to lineal descendants or Indian tribes or NHOs with potential cultural affiliation. Now, for many museums, this is the last step that is required in the process. Oh, sorry. Until they hear back from an Indian tribe or an NHO that wishes to consult. So it's important to recognize that this is the last required step for a museum until there is an action by an Indian tribe or NHO. So the summary process, the repatriation of cultural items, may pause after step 2 until an Indian tribe or Native Hawaiian organization makes a request to consult. And once that request to consult is received, then there is an obligation to respond to that request. And there's an obligation to consult with any consulting party that wishes to consult. This is an ongoing obligation for museums and federal agencies. So again, the intention of a summary is to provide transparency about what possible cultural items are in a collection. Once that information is shared with Indian tribes and NHOs, it is then up to the Indian tribe and NHO to decide that they want to consult, or they could decide to request repatriation of an object. And that is a difference in the summary process, a significant difference in the summary process. And it's important to keep in mind that timeline is dependent upon the request of Indian tribes or NHOs. So looking ahead then to how repatriation actually occurs. Once a summary is compiled, invitations to consult are sent, and either there is consultation or there is a request, a direct request for repatriation. This is when the repatriation process and these final steps occur. So it is, again, an obligation for a museum or federal agency to receive and consider those requests. And the request should meet the criteria that is listed here for a request. The criteria is that the object meets the definition of a particular item under NAGPRA, that there is cultural affiliation, and some assertion that there's no right of possession to the object. Right of possession is a difficult topic to discuss in a general seminar or general webinar like this, but it is a critical one, especially to the repatriation of cultural items process. And I would encourage you to look closely at the definition of right of possession, but also at some of the Q&As that we've provided. In looking ahead to the next step for the process, there is a requirement for museums and federal agencies to respond to all requests for repatriation that they receive for those cultural items. And the response in the updated regulations, the required response is one of 4 options. A museum must, or federal agency must respond to a request for repatriation with one of these 4 options: that the request meets the criteria, that the request does not meet the criteria, and request additional information from the party that made the request. Or the museum could say that the request meets the criteria, but the museum is asserting a right of possession to the object. Or the final option is for a museum to show, to say that there are competing requests. I think I forgot to switch my screens. I'm sorry. Thank you. We have a lot of questions coming in, and I just want to encourage you to upvote those. We will likely not be able to get to all of the questions that are coming in. So we will try to answer them in terms of the most popular questions during this session. Following a request for repatriation, then in step 5 and the response to that, if the request meets the criteria, then the next step is for a museum to publish a notice of intended repatriation. A notice of intended repatriation, again, comes after a summary is compiled and after there is a request for repatriation. And a notice is a general summary of information from the summary, an abstract of the information from the summary itself, along with information about who is making the request and the date on which repatriation can occur. This is the very end of the process of repatriation for cultural items, this process of the notice. The notice, again, provides opportunity for other parties, parties other than the one making the request, to come forward, or it provides for that last opportunity for additional parties to come forward. So following the notice then is the repatriation statement. And this is, again, a new requirement in the revised regulations to complete the process by issuing a repatriation statement to the requester and sending a copy to the National NAGPRA program. This is the final step of the regulatory process, the final piece of paperwork, but it may not be the end of the process in terms of the museum, federal agency, or the tribes involved. Following this repatriation statement would be physical transfer, if that is what is desired. Other kinds of agreements or arrangements might be made about where the physical custody of the item might be. And it's important to keep in mind that while this is the end of the regulatory process, it may not be the end of the process entirely. So this brings us then to this timeline. Again, you can find this timeline in the steps to repatriation document. This is an estimated timeline of how this process might play out in both the shortest number of days as well as a longer time frame. And again, these are just estimates, and the main variable here are those items that are marked with the star. Those are activities or steps in the process that are dependent upon an action by an Indian tribe or an NHO or a lineal descendant. And therefore, we have only estimated them to be the same day as the previous step or the day after. It will obviously likely be longer than that. But in order to make these two timelines comparable, the focus here is only on the actions that are required by museums and federal agencies. So in looking again at the shorter timeline, from the day that a collection is received by a museum or federal agency, if they were to compile a summary in one day and send out those invitations to consult the next day, if consultation happened immediately, as did a request for repatriation, the entire process could be completed within 39 days. On the longer timeline, you can see that the process for compiling a summary could take up to 6 months. That is the regulatory deadline for compiling a summary of a new collection, is 6 months after it's received. And then 30 days after that, is the requirement to initiate consultation. Again, the estimate is the same here for the consult and request and consider request steps that are dependent on the timeline of an Indian tribe or NHO. But if those happened immediately, then the same timeline could play out using the maximum number of days allowed in the regulatory process. It could take a total of 449 days to complete the repatriation statement. So there's a lot of discretion here. You can see between 39 and 449 days for how a museum or federal agency will undertake these requirements. Now, again, I just want to emphasize again that this does not include that variable of the timeline of an Indian tribe or NHO. And again, to reiterate that continuing on to step 3 and beyond for this process is dependent upon action by an Indian tribe or NHO or lineal descendant. I am going to go back to my screen that had the definitions, because I see that we have quite a few questions related to the definitions under NAGPRA. And again, these are taken from the regulations themselves. And you can, again, you can find this document on our website. Let me take a minute to look through some of the questions that we have. And I apologize if I pause or delay here, but I want to be sure that I'm taking the time to see and respond to the questions. Again, if you have a question, you're welcome to put that in the Q&A. We will be taking questions that way during this session. Okay. All right. Yeah, the question about the requirement for geographical location. The regulatory language is here. Geographical location meaning provenience, or the place that the objects were removed from or taken from, as opposed to provenance, meaning how they were acquired or where they have been housed since they were acquired. All right. Next question is, let's see. The next question that we have in terms of the number of votes is if I can provide an example. Oh, sorry, I just refreshed my screen. All right, it looks like the top question right now is, if there's no response from an Indian tribe or NHO following initiation of consultation, what is the next step? There are instances where we're not certain whether items are objects of cultural patrimony or not. Thank you very much for that question. That is a really important question and one that gets asked a lot. And I tried to emphasize the answer to that in my presentation, but let me just go over it again. And let me do that by using this page of the steps to repatriation document so that we can see all of the steps together on one page. Okay, so yes, as I mentioned, the first step is an obligation of a museum or federal agency to compile a summary. They have to do so within a certain timeline, and then 30 days after that timeline, they must initiate consultation by sending a copy of that summary to potentially culturally affiliated tribes or lineal descendants. At that time, a museum or federal agency has fulfilled its obligations until it receives a request from an Indian tribe or NHO. And that request could be to consult, or it could be a request for repatriation. Either are acceptable after this step too. But the timeline does stop there. And the question that was asked is, if there's no response from a tribe, what's the next step? Well, there are no obligations under NAGPRA for the next step. You generally have an obligation to care for those objects that are in your collection. Certainly, as I think most of you are aware, there are additional requirements in the revised regulations for a duty of care for objects, and that would include limiting or restricting, I should say, access, as well as research or exhibition of those items. Now, that's going to depend largely on what you know about the object in question. And we've talked about this in past webinars, and I know that this is a common question, and it's added here in this question that we received. The question says, there are instances where we're not certain whether items are objects of cultural patrimony or not. And in those cases, yes, there may be many objects in a collection that you are unsure if they meet a definition under NAGPRA for an object of cultural patrimony or a sacred object, or even for a funerary object. And while you may include those, and you should really include broadly as many objects as might meet those definitions in a summary, the actions that you take after initiating consultation for those objects is going to depend on what you do know about those objects. And it may not be until you do consult or receive a request for repatriation that you're able to identify whether an object is an object of cultural patrimony or not. So the next step is really to continue to be a museum or a federal agency, and to care for these objects and to care for these items, and to prepare if you were to receive a request to consult or a request for repatriation of those items. I hope that answers your question. I know that it's probably not as definitive as maybe you would like, but the reality is, once you finish step 2 of initiating consultation, a museum or federal agency is really in a holding pattern. They have an obligation to respond to requests from Indian tribes, but Indian tribes and NHOs are not obligated to make those requests in any kind of time frame. The next question relates to the definitions. Let me just refresh. There was a follow-up, I think. If a museum wants to exhibit an item that is a possible object of cultural patrimony, submits a summary and reaches out for consultation, that object still cannot be exhibited without explicit permission. Is this correct? I'm not going to be able to give you a yes or no answer to this question. Again, it's going to depend very much on what you know about the object, and whether you know that the object is very likely an object of cultural patrimony or a sacred object. I know that this is a simplified answer, but it's the best that I can give you. If your catalog card or your exhibit label for an item says this was used in ceremony, or this was collectively owned by a tribe for an important historical or cultural reason, those are indications that this meets that definition. And that object then is very likely an object of cultural patrimony or a sacred object. In cases where there's more questions about what the object is, or there's a lack of information in the museum records that would help you to identify whether that object meets a category under NAGPRA, then a museum or federal agency needs to make that decision about whether to exhibit it or not, whether to allow research or access to that object or not. at their discretion, and they need to use their best judgment. So where you're lacking consultation information to clearly identify those objects, you have, as a museum, you have to exercise that discretion in your decision making. I hope that's an answer that helps, even if it may not be as clear of an answer as you were hoping for. I think that this is probably a very good time to remind everybody that museums and federal agencies have discretion and decision-making authority under these regulations and under the Act itself. That has to be exercised within the parameters of what these rules require. But where there are gray areas, museums have to figure out, museums and federal agencies have to figure out how to exercise that discretion. All right, the next question is about the what seems to be a new emphasis on the definition of cultural traditional knowledge. The question reads, we have provided summaries on cultural items, but based on our interpretation of the definition, do we need to reach out again with a summary of all Native objects? This is a good question. It is one that we tried to answer in the frequently asked questions. Let me see if I can find the right number. Yes, number 4. Should a museum include every Native American object in a collection in a summary? You definitely don't need to include every Native object in a summary. A summary is not required to include all Native American objects in a holding or collection. That's not what the Act requires. However, as we've just discussed, museum records may be lacking in information necessary to identify cultural items in a holding or collection. Therefore, it is our advice, and the regulations require, that a summary include any holding or collection that may contain a Native American cultural item. So meaning the specific categories of cultural items. So again, a museum should make this decision about what to include in a summary based on what it knows, but also where it lacks information. Those are both ways that a museum can exercise this discretion on what to include in a summary. For the question of whether you need to reach out again with a summary, you are not prohibited from sending another summary or providing additional information in a summary and sending it out again. You are not required, however, if your previous summary was comprehensive and covered, broadly covered your collection. Again, the intent of a summary is to be transparent about what is in a museum's collection and to provide that information to tribes. So hopefully, if the summary was broad enough when it was first issued, and again, looking at the examples that we've provided, if you have several paragraphs like this descriptive paragraph that describe broadly a holding or collection, then it is likely sufficient and doesn't need to be resent. Now, again, that does not prohibit you from doing so. It's just that it's not a requirement. All right, the next question is another good one. If we sent out summaries in the early 1990s, but the number of federal recognized tribes has increased since then, does the museum need to send a summary to those newly recognized tribes as well? And what's the timeline? Thank you for asking a question. I can say, yes, you must send out a summary to the newly recognized tribes. And the timeline is, well, the timeline is not in this table, but I'll pull up where it is in the regulations. There is a requirement under step 2 to provide, to initiate consultation when a newly federally recognized tribe is identified. So you are required not to redo a summary, but to send a summary to newly federally recognized tribes. Let me pull up that timeline for you. Do it this way. So under step 2, initiate consultation, there's paragraph 3 here, which says that when a museum or federal agency identifies a new consulting party, an invitation must be sent. It's 30 days if a new party is identified based on additional information, or 6 months if that is a newly federally recognized tribe. So the timeline for sending a summary to a newly recognized tribe is 6 months after they are recognized. So it may be that if you have not sent summaries since 1993, there are several Indian tribes that have been recognized since 1993, you would want to send those invitations to consult to the newly recognized tribes. Okay, the next question is, can repatriation requests be made without a request for consultation? Say, for example, the information sent with the summary is adequate for a tribe or NHO to determine cultural affiliation. Absolutely. And I tried to mention this in my presentation, but thank you for asking the question so I can reemphasize. After an invitation to consult is sent in step 2, the options for a tribe are to either request to consult or request repatriation. This process could go straight to step 4, and an Indian tribe or NHO could submit a request for repatriation without consultation occurring. That is absolutely possible under the regulations, and the regulations provide for that option. And that is exactly because if information in a summary is sufficient, or if a tribe has information that they can make the request directly for repatriation of an object without requiring consultation. Now, most of the time, tribes start with asking for consultation, but that is not a requirement. Okay, there is a question that I don't think I can answer about whether there is a feed that can be followed to be notified when there are updates to the NAGPRA website. I'm not aware, I'm looking at the bottom of the screen now, of a way to get that kind of a feed, but if there is anybody out there who has some other solution for that question, please feel free to chime in. You know what, I think that I will tell you that we're working on a lot of documents right now. We're hoping to make a lot of updates over the next week or so to both the policy page as well as the templates page. But at that point, I'm not sure how much more we'll be producing. Obviously, our intention is to continue to update these as issues are identified. We do plan on adding more questions as we receive additional frequently asked questions. So there may be ongoing updates. We have tried to indicate when the last update was posted, so hopefully that will help. I realize that that's not quite the solution that you were looking for, but I'm afraid that's the best answer that I can give you. All right, the next question we have, do the rules address the issue of deadlock when there is a conflict among claimants as to who the cultural item should be repatriated to? Or is it still as it was in the Act and the previous regulations that the cultural item stays with the museum, federal agency? It's a good question. And the revised regulations are the same as the Act and the previous regulations. in that it is the requirement of a museum or federal agency to try to determine which is the most appropriate requester in a case of competing requests. Let me say that again. It is the obligation of a museum or federal agency to try and determine who is the most appropriate requester. We have provided in the revised regulations additional guidance for how a museum might evaluate competing requests. Hopefully, with that additional guidance, a museum will be able to identify a most appropriate requester. That's what the requirement in the regulations and the old regulations and the statute are, that a museum try to identify a most appropriate requester. When they cannot, when a museum or federal agency goes through the process and cannot determine a most appropriate requester, then the museum must hold on to the cultural item until there is a resolution to those competing requests. So the answer to your question is, yes, it's the same, but we have added additional information in the regulations to help address this issue. So I hope that that's helpful. In the regulations, you can find this, it comes after the steps. So at the end of 10.9, after step 7, there is a section that talks about evaluating competing requests. And you can read through and follow that guideline in terms of what the process is. I want to say that this question comes up a lot, and I want to stress that it can't be addressed until you get to receiving requests and receiving multiple competing requests. It's very important that, well, it's my experience that museums and federal agencies can tend to anticipate competition or conflict. And the reality is that we don't see that. That's a more rare case. So again, the instructions are there, the guidance is there in the regulations. But walking through this process and going through the step-by-step process, you need to wait to engage in that effort until you get those competing requests. Okay, let me refresh my counts here. Next question is, archaeological items that in the past did not meet the definition of cultural items and therefore never requested for repatriation are now eligible for repatriation due to a deference to traditional tribal knowledge. All items have the ability to be claimed even without discussion as to why they fit the definitions. Is this correct? I'm going to rephrase the question. And I think that it goes back again to the definitions. So let me find the correct document here and pull up the definitions in the regulations themselves. It's important to note that from the time NAGPRA was passed, the legislative history is very clear that the definitions of cultural items under NAGPRA were intentionally broad to provide opportunity for different tribes with different cultures and different histories to bring different information to meet these definitions. So I would argue that there is not a significant change in these regulations as to what meets the definition of cultural items. Rather, what we have done with these regulations is re-emphasized what Congress intended in 1990, that it is through input and information received during consultation or from Indian tribes or Native Hawaiian organizations that museums have information they need to be able to identify whether an object meets a category or not. The last part of this question about the ability to have objects have a to receive a request for repatriation, even without consultation. It doesn't mean that it's without information. Again, remembering that a request for repatriation needs to assert that an object fits a category, fits one of these definitions, and that the requester is culturally affiliated. It is still incumbent upon a museum, though, to make a decision, a museum or a federal agency, to make a decision based on that request for repatriation. So while it may appear that the revised regulations provide a broader opportunity for requests, I would say that we're really just putting into the regulatory language what Congress intended, which is that Indian tribes and Native Hawaiian organizations have the right to present their request to a museum or federal agency for any item that they believe meets the categories under NAGPRA and should be repatriated. It is then incumbent upon the museum or the federal agency to make a decision about that request. I hope that helps with the answer. All right, there was a comment, more than a question, that it is important to reach out to tribes multiple times, emails, phone calls, and more than once. Sometimes there are only one or two people in an office, or offices are closed due to traditional and ceremonial events. Absolutely, that is true. That is true of any effort to build or sustain a relationship with any person or entity, not just Indian tribes or Native Hawaiian organizations. So yes, I think that it is important to reach out multiple times if you're interested in effective relationship building and consultation. I want to be clear that any statement I make about when a museum or federal agency must contact a tribe is about what is required under the regulations. And again, the regulations set the baseline of what is required. There's certainly so much more that people can do to build on top of that foundation. Okay. Can I provide an example of an object of cultural patrimony? That's the next question here. I have on the screen the definition of object of cultural patrimony. There are some regular examples that have been used in the past to describe what an object of cultural patrimony is. Objects like a Zuni war god, for example, was previously used in the regulations as an example of what an object of cultural patrimony is. Meaning an object that has a central importance to a tribe, that it has a historical, traditional, or cultural importance, and that object could not be owned by an individual of the tribe or an individual person, and could not be sold or given away or conveyed in any way by an individual. Those are, that's a kind of general example that's used. I think that another example that might make this a little bit more relevant another example to put it in a different context. There are lots of kinds of cultural patrimony that are not necessarily within the Native American context. So not NAGPRA, but under any kind of objects that are collectively owned by a group of people or by a nation, are examples that you can think of. So there are very clear examples to us of what are objects of cultural patrimony to the United States of America. Things like the Declaration of Independence, the Statue of Liberty, despite its size, would be equivalent object of cultural patrimony. These are items that cannot be owned by an individual person, but belong to the United States people as a whole. That, in general, is what an object of cultural patrimony is. The follow-up to this question is that it's really up for the tribes to decide what an object of cultural patrimony is. And that is accurate in that it is the people within the culture itself that have the information needed to identify the significance of an object to a culture. So I think that it's difficult based on just looking at museum records to identify an object of cultural patrimony unless those records are clear that this is an object that was used by an entire group or that it was an inalienable object, that it couldn't be separated from the group itself. And we have plenty of examples of objects of cultural patrimony in notices that have been published in the Federal Register. And the best source for examples is those notices. A notice is going to give you not only the category that an item fits, so object of cultural patrimony or sacred object, or in lots of cases, objects that meet both the definition of sacred object and object of cultural patrimony. And it's going to give you a description of that object. So I would very much encourage you to take a look at some notices of intended repatriation in the Federal Register for other examples of what are objects of cultural patrimony under NAGPRA specifically. Okay, the next question, do we put together one summary covering all cultural items or separate summaries for each geographical location or tribal nation? So the response here is correct that you put together one summary, but you might want to organize your summary according to geographical location or other ways of maybe organizing information. Because again, remember, you have to send an invitation to consult. And that invitation could be sent to all tribes who are connected, or it could be targeted. So again, looking at the examples that we have in this document here, you might say that certain objects from a certain part of the country would be sent to a certain number of tribes. And instead of sending the entire summary to all the tribes, you would send pieces. However, you can organize this in whatever way makes sense to you and to your museum. Do we need to resend a summary if the number of tribes that we consult with increases? So there's a kind of a conflict in this question. You have an obligation to identify potential culturally affiliated tribes and to send them an invitation to consult along with a copy of your summary. If you then get a request from somebody that you did not invite to consult, you have to honor that request and you need to consult with them or consider a request for repatriation. It doesn't necessarily trigger that you have to invite them again. You know, the getting a request to consult, you have to respond to that request to consult, whether or not the individual received an invitation. You would need to keep record of any additional consulting parties that you didn't first reach out to. You also need to share information with that new party if they didn't receive the information when you first initiated consultation. So it is important that you keep a record of who you consult with. And it is important that you share information with new consulting parties, but you don't necessarily have to resend a summary when you have a new request to consult. The next question I think I answered in part. Do you send the entire summary to every tribe, or do you only send relevant parts of a summary to each tribe? That is up to you. How you organize this process in terms of how you organize your summary and how you organize those invitations is up to a museum to decide. And a lot of that's going to depend on what the characteristics of your collection are. All right. Another question here. If there is the possibility that cultural items are associated with ancestors at other museums or are already repatriated, but we don't know for sure, should these cultural items be included in a summary until we find out if they are associated? So this gets at funerary objects in particular here, where there are funerary objects in a museum, but there are no ancestors present in the museum, and the museum is not sure where the ancestors are. Should they be included in a summary until you discover where the related human remains are? We again tried to clarify in the definition of associated and unassociated funerary objects in the regulations. So where the human remains, where you know where the human remains are that are connected to a funerary object, that is what makes a funerary object associated. When you don't know, and again, I'm not going to say where you're unsure, I'm going to say you know or you don't know. And a museum needs to make that decision about what they know and what they don't know. So when you know, it's associated. When you don't know, then it's not associated. And it would be unassociated until you get additional information. And that's captured here in the first number. Under the definition of unassociated funerary objects, the location of the human remains is unknown. The follow-up there is, who determines if they are associated? Well, again, the information is going to determine if they are associated, although I will note that objects that are made exclusively for burial purpose are always associated funerary objects, regardless of the location of the human remains. So it could be that the tribe has information that it could share during consultation or in a request for repatriation that identifies an object as one that is exclusively made for burial purposes or to contain human remains. And in those cases, that information would show that it's an associated funerary object. Again, who makes determinations under NAGPRA? Determinations are made by museums and federal agencies, but that must be done after consultation with Indian tribes and NHOs. So information to show that an object is an associated funerary object could come from consultation, or it could come from learning additional information about the location of the human remains. So a question about clarifying about newly recognized tribes. I cannot seem to find a list of tribes who were recognized in 1990. It would be helpful to have this in order to compare with the current list of federally recognized tribes in order to sort out who to send summaries to. That's a good question, and a suggestion about checking on the Office of Federal Acknowledgement to see if there is such a list. I'm not aware that there is, but the list of federally recognized tribes has been published in the Federal Register since 1994. And we can work to make a link to that early list of federally recognized tribes available to you, or you can try to find it yourself on the Federal Register, and that would give you the information. But maybe a better approach here is to think about what you know about your collection in terms of cultural groups or location, and then to consider the list of federally recognized tribes that are related to that culture group or to that location, to be sure that you have sent invitations to all the appropriate parties. And I say that because tribes are going to be recognized across the United States, and they just because they're newly recognized, they may not have a connection to the collection depending on what the information you know about your collection. I hope that makes sense. Okay. We have a question about whether a correction to a notice is needed if there are competing requests received after a notice is published? This is a very good question, and this is something that was that has been clarified in the updated and revised regulations. Again, I really enjoy questions that I can answer with clear yes or no's, and in this case, the answer is no. You do not have to publish a correction notice or an amendment notice when you have competing requests and repatriation proceeds to a tribe other than the tribe listed in the notice. Now, I say that you do not have to. It's not a requirement. If you follow the step-by-step process in the regulations and you publish your notice, you have competing requests, and you follow the process for resolving a competing request, it ends with sending a repatriation statement along with a clear determination on who is most appropriate. So there's ample opportunity of notifying the parties involved, but there is not a requirement to publish a new notice or correct your notice. However, I will say that in some cases, tribes have requested museums publish a new notice. And in those cases, we will assist you with publishing what we would call an amended notice, but it is not a requirement to do so. Okay, the next question in my list is related again to the question of objects of cultural patrimony. And that this is very broad, so this could be any number of items could be determined through consultation to be an object of cultural patrimony. That is correct. Follow-up to this is that there is discussion about animal burials, dog, coyote, cougar, that are being repatriated as objects of cultural patrimony because they do not fit the definition of a sacred object. And the question is, could I please speak to this? We certainly have seen examples where ritual burials of animals, separate and apart from the burial of human remains, have been repatriated under NAGPRA. I would say that a ritual burial, depending on the beliefs or customs of a tribe, may fit the definition of object of cultural patrimony, or could also fit the definition of a sacred object. And those certainly could be subject to a request for repatriation and repatriation under either of those categories. Again, it will depend largely on the information available about the animal burial and the traditional knowledge, certainly, and traditional practices of the tribe that's making the request. But we have seen animal burials, ritual animal burials repatriated under NAGPRA. Okay, there's a question following up. Let me just resort for a minute. I don't want to miss the flow of the conversation, but at the same time, I want to try to answer as many questions as I can. Okay, so one question about items that were previously repatriated before the new regulations were issued. And there was no repatriation statement because that was not a requirement. Should we send statements for those objects or ancestors in the case of inventories and human remains that were repatriated before the new regulations that went into effect? That is up to a museum or federal agency to decide. My general advice is, if you did not do some kind of transfer of control after publication of a notice, so again, notice first in either case, followed by some kind of documentation of a transfer or repatriation, then I would encourage you to issue a repatriation statement to ensure that there is a clear paper trail on what occurred after a notice was published. Now, in many cases, following publication of a notice, there is an immediate physical transfer, or immediately after the notice waiting period of 30 days. In those cases, a museum would want to be sure it has a clear record or a clear document indicating the physical transfer. But there's no obligation to report that information to the National NAGPRA program under the previous regulations. What the new regulations do is require that final step in a process for a museum or a federal agency to issue a repatriation statement after a notice is published to kind of clarify the end of the process in terms of the regulatory process. So I hope that answers your question. In terms of how that is reflected statistically, either on our database, remember that previous to these new regulations, our records have been about what is published in notices. And so certainly for human remains and associated funerary objects, we have a list of those ancestors and objects that have not been published in a notice of inventory completion. And that, that is the process by which items are removed from an inventory, is the publication of that notice. As many of you know, or those of you who may have submitted repatriation statements, we are working on a way to reflect repatriation statements with the notices that are on our database right now. And we hope to have that information publicly available soon. We're still working through the technology of that issue. All right. We have just a few minutes left, but I will try to answer a few more of the top voted questions. If an object was donated and cataloged in the 1930s as affiliated with the tribe, and we do not think that information is accurate, do we send that to the tribe or to the one we think it should go to, or both? Our practice is to send to both. This is the follow-up. Our practice is to send to both so they have an opportunity to confirm and discuss. I would say that when it comes to transparency and information sharing, as broad as possible is the best policy. The broader your reach with information sharing, the better the process will go. I would say, though, in this case, that where you have information about an object, you need to honor that information that you do have. And where you say here that you don't think that information is accurate, I would question what the basis for that is. Is there some additional information, either that you can see from the object itself that indicates a different tribal connection, or information about other repatriations that influences that questioning? I mean, I guess you don't want to discount information that you have because it's from the 1930s. That's not a sufficient reason to discount the information available. But where you have additional information to suggest additional tribes may have an interest, absolutely. The broader, the better, in terms of sharing information and ensuring that everybody has an opportunity to understand the collections that you have. The next question gets to the right of possession issue that we discussed. Is it the tribe's burden to prove or show ownership, or is it the museum's? And when we're talking about cultural items, so not human remains or associated funerary objects, but these objects of cultural patrimony, sacred objects, and unassociated funerary objects. As I mentioned, in the requirements of a request for repatriation is information to show that the museum does not have a right of possession. And so in the first instance, when a tribe makes a request for repatriation, there is an obligation for the tribe or NHO or lineal descendant to state that they don't believe the museum has a right of possession, that they don't have a right to own the object. That can come in lots of different ways, that assertion of no right of possession. And it can come inherently because the object could not have been alienated from the tribe. It could come from information the tribe has about the time in which the object left the community, and the destitution or circumstances of the tribe at the time that it left mean that it only left under duress. There are plenty of ways that you could show that first assertion that a museum does not have a right of possession. The burden of proof to show right of possession is on a museum. A museum or federal agency must provide information to overcome that initial assertion. So this, as I mentioned, this can be a very difficult subject to kind of talk about casually, because it's rife with these very legal terms. But it is a process that is built into the act itself, where in the first instance of making a request, a tribe has to say, you don't own this, you couldn't own this. And then a museum must overcome that. They must prove that they do, that they can, that they have evidence to show a right of possession, a right of ownership to the object. Again, this is particular to the summary process and to sacred objects and objects of cultural patrimony. There are, there are maybe better examples or other discussions that would help illuminate this issue. And we included several of them actually in the final rule, some examples. And we do intend to publish a template as well as some guidance for making requests for repatriation, which will include some additional guidance on this question. Okay, a question about steps 2 through 4, because I failed to correctly share my screens, and I apologize for that. Certainly the requirements for step 2 through 4 are here in this document. And again, this is the steps to repatriation document, which you can access through our website. In terms of what was on the slide that was in addition to that, it would be those other 2 columns of what is not required, what is not prohibited, but what is not required, and then where there is some discretion or a question about how to proceed. And again, we hope to be able to have this entire PowerPoint presentation available soon, and it will be on our events page, where the registration and recordings of these sessions are available. Again, I apologize for my failure to share my screens effectively. It's a lot to manage. Thankfully, I have Lisa here helping with some of the questions, and Mariah with the links, and I appreciate very much the team support that goes into these. But pushing the buttons on my screen falls to me. A question about what qualifies as correspondence or documentation and sending letters. Does email qualify, or should we expect a formal letter? Email is fine. There definitely does need to be proof of a read receipt or a sent receipt, some way of knowing that the email actually went out. But email is fine. Written documents can be sent by email or by mail or other delivery services. It is important to note that email is the limits of technical delivery of documents at this time. So no Facebook Messenger, no Snapchat. Those are not ways of sending written documents for purposes of these regulations, but email is fine. And I will add that the National NAGPRA program prefers that all documents that are required to be sent to our office be sent by email. We have a couple more that I might be able to get to here. Is there a resource that offers guidance on how to handle possible cultural items from Mississippian culture? There are over 20 plus descendant tribes. Is the expectation that the museum gains approval from 20 plus tribes in order to make the item available for exhibition or research? Well, certainly where those objects are clearly funerary objects or sacred objects or objects of cultural patrimony, and certainly where they are human remains, consultation with those 20 tribes would be a requirement, and some consent prior to research or exhibition would be required. A follow-up to that is whether my office, the National NAGPRA program, provides a list of which descendant tribes must be consulted in each case. The answer is no, because the list of who must be consulted is going to depend very much upon the information that you have about your collection. Not only its cultural connections or cultural associations, but also where it was removed from, also the acquisition history. Those are all important pieces of a puzzle to identify the consulting parties. And certainly starting consultation is the best way to identify consulting parties. It may be that once you start consultation with one tribe or several tribes, you may be able to identify additional consulting parties and gain more information. The best source of information about consultation are the tribes themselves. There is an additional suggestion to check the Federal Register for similar sites, and I would agree. Always, the Federal Register provides a wealth of information about what other museums have decided, museums and federal agencies. But again, NAGPRA depends upon a case-by-case determination based on the information that you have. So because one museum consulted with someone doesn't mean that you have to, but can be a helpful way of identifying consulting parties. I'm going to just do one more refresh and see what we've got at the top here. And of course, we have several questions that are top rated right now. So I will see, I'll answer the oldest one first. And that is, for future sessions, can you provide us with information that differentiates state NAGPRA laws from federal? For example, California NAGPRA and national NAGPRA. There seems to be confusion between the two. Thank you for the question. Unfortunately, I cannot provide definitive advice or guidance on state law. That is not my job. My job is to provide guidance and information on the federal law. And we have provided some assistance, especially in the case of California, about where the two laws intersect and interplay. We continue to work with the Native American Heritage Commission in California to assist with disseminating information about the California state law and the federal law. But if you have more specific questions, you're welcome to reach out to us directly. So a future session will likely not revolve around state laws in particular, but we might be able to work a little bit on, again, where there are discretionary acts or points in the federal process. And that is where those state laws or other policies or other guidance might come into play. And with that, I'm going to have to end our session today. We will work to try to review and incorporate some of these questions into our future guidance. And I appreciate, again, so much of your time and your attention, and certainly your interest and effort on this subject. Our next session will be next month on April 19th, I believe is the date. And we look forward to seeing you then. Thank you.